All right, so revision lecture number 2. We're going to start by going back over the topics from lectures 3 and 4. We have some important topics tonight, in particular because we're going to look at hearsay, similar factor evidence, etc. But there's some other important topics as well that you should be aware of. So we're going to start with the concept of corroboration. Remember I said last night that previously the evidence of child witnesses needed to be corroborated. What we mean by corroboration is there needs to be some kind of independent, extraneous source to back up, in other words, the testimony of certain categories of witnesses. So in Hong Kong, a lot of the rules about corroboration have been abolished, except for in certain exceptional circumstances, like, for instance, perjury still needs evidence of corroboration. When it comes to certain categories of witness, their evidence was felt to be more suspect, more easily manipulated than other categories of witnesses. So that's basically the foundation, the background for the rules on corroboration. Now, there's no longer a formal requirement for the evidence of these kinds of witnesses to be corroborated. Instead, what the judge will do is, on a case-by-case basis, depending on the facts and the evidence of the witnesses, decide whether he needs to give a direction to jury members on the need for caution. And that's the case in your evidence law notes of the Queen and Mackin jeweler as applied in Hong Kong and Chu Ip Pui. So if we look at this in your unit guide, it's pages 60 onwards. So you can see here the judge has an unfettered discretion whether to warn the jury that they need to treat the evidence of these witnesses with a degree of caution. For example, it may be that the judge decides that he doesn't need to give them any special warning, but where the witness has been shown to be unreliable or has shown to have lied or to have previously made false complaints, or perhaps there's a history of bad blood between, say, the witness and the defendant, say the witness may have some grudge, then a stronger warning may be appropriate, and the judge may suggest it's wise to look for some supporting evidence before relying on the impugned witness's testimony. Okay, so there's a great deal of discretion now when it comes to how the jury should deal with certain categories of witnesses. And then if you look at pages 61, these are some of the categories of witnesses that the judge may consider giving a warning to the jury about. For example, accomplice evidence, right? A former accomplice. Obviously, they may have a reason to fabricate their testimony. Witnesses who are testifying under an immunity from prosecution. So they have gained something from the prosecution as a result of their testimony. Witnesses who have improper motives. They bear a grudge against the defendant. They're biased against them in some way. Those which have mental illnesses. And then when it comes to the evidence of a child, because that evidence no longer needs corroboration, whether there is a need for caution will depend on primarily the age of the child, whether they really understand the need to tell the truth, etc. Okay? So that is corroboration. Okay, and you can see here on the next slide, I've just summarized for you some of these examples of witnesses where the judge may need to consider whether there is a need for caution when it comes to how to deal with their testimony. Topic 12 was really a topic in which we kind of went through the sort of formal procedures for how a trial works. But remember, this was back before we had done the criminal procedure course. So I think now you're very familiar with it. So we don't really need to go back through it. Just remember that when it comes to witnesses, they are not always allowed to be present in court and should not be present if they're a lay witness. Only the defendant's allowed to sit in and listen to the testimony. The exception is expert witnesses with the permission of the court because they are professional and supposed to be more independent. There's less of a risk that their testimony may be changed depending on what they hear from other witnesses. So that's the position in criminal trials, but not in a civil trial. The reason the rule is different is in a civil trial, the witnesses are essentially bound by the contents of their witness statement, and often those witness statements stand as their evidence in chief. So again, there's less scope for them to change their testimony. If it's examination in chief, then as a general rule, the advocate can't ask leading questions which suggest the answer or which assume a fact not in evidence. But there's 6 exceptions here. For instance, on undisputed background introductory matters. If there's a need to refresh a witness's memory, which we'll look at in a minute, if the witness has been declared a hostile witness, then you may be able to lead that witness. Memory refreshing is a technique that you use with your own witness in examination in chief. And it's a technique that you may need where the witness has forgotten some important detail. This is kind of a situation of last resort, though, because ideally, to avoid you having a situation where a witness needs to refresh their memory in court, because anytime a witness needs to refresh their memory in court, it essentially undermines the credibility of their testimony. right? Because they are admitting that they can't really remember what happened. So they need to look at a more contemporaneous document. So to avoid the need for this happening in the first place, as a matter of good practice, you should always get your witness to read a copy of their witness statement before they even begin their testimony in court. But if worst case scenario happens and they've still forgotten some important detail, then you will need to ask the court for leave to allow the witness to refresh their memory. The idea is that the court prefers the oral testimony of a witness, and testifying in court is not just about sitting there reading out the contents of a witness statement. Okay, so in a criminal trial, you may need to ask leave of the court for the witness to refresh his memory. And in order to do so, you first need to lay the foundation. So it has to be established that the witness has forgotten some important detail, so there is a need for them to refresh their memory. You'd have to establish that there is a contemporaneous document that was compiled either at the time of the incident or shortly after it. It doesn't always need to be a witness statement. It could just be something written down on a piece of paper, like on the back of a check or receipt or something. You also have to establish with a witness that when they made that note on that document, that it was an accurate note, and that it was complete, like it fully reflected what occurred. And if the witness is permitted to refresh their memory, then they are allowed to read through this document, and then they have to really put it to one side and then read out the contents of the document. Generally, the document that they are refreshing their memory from is not exhibited as an exhibit in the case. And in a criminal trial, if it was to be exhibited, it wouldn't be proof of the truth of the contents. But that is different in a civil trial. It is admissible as proof of the truth of the contents. That's just because of the different provisions of the evidence ordinance. So remember that refreshing a witness's memory is a special procedure for your own witness in examination in chief, where they have forgotten an important detail. It's different from a situation where the witness has previously made inconsistent statements. And in a minute, we'll talk about cross-examining on a previous inconsistent statement. That's a different procedure from this memory refreshing. The next topic we looked at was previously consistent statements. The general rule is that a previous statement that the witness has given before the trial that is consistent with their oral testimony now at trial cannot be admitted. So proof that the witness said the same thing on a previous occasion that he's now saying in court is not admissible as a general rule. The reason for that is it may give artificial weight to what they're now saying in court, right? Because we tend to believe that the more times something is said, the more truthful it is, right? The more reliable it is. So that's the foundation for the rule against previous consistent statements being admissible. But there are exceptions. In civil proceedings, they can be admissible with leave of the court, or to rebut an allegation that what the witness is now saying is just a recent fabrication, or as a memory refreshing document. And if it is admitted, it's admissible as proof of truth of the contents. But in criminal proceedings, there are also exceptions. So it could be admissible as a memory refreshing document, can be admissible in a case of previous identification, right? And we know that doc identifications are not objectionable in all circumstances, right? A witness is permitted to, in the course of their testimony, turn to the defendant in the doc and say, yes, this is the person that I previously identified in an ID parade. That is a form of a previous consistent statement, right? They are confirming an earlier statement that they made. That is a permissible exception. So is a complaint in a case involving a sexual offense. So let's say that the defendant is charged with indecent assault, and there is evidence that on a previous occasion, the complainant, like, let's say, went to a social worker and complained that she had been indecently assaulted by the defendant. That previous consistent statement is allowed to be introduced in the defendant's trial. The reason for this exception is because these types of sexual offenses, rape, indecent assault, don't tend to take place in public, right? They tend to take place in a secret location. So that's why there is an exception for a recent complaint where a sexual offense is involved. Also can be introduced to rebut an allegation of a recent fabrication, and also an exception for a statement made on an accusation. For example, the fact that when the defendant was arrested, he made a confession to a police officer at the scene of his arrest is admissible, even though it's a previous consistent statement. Or the fact that in a record of interview, he admitted committing the offense. Also, that is admissible. It's because it comes within this exception. So the defendant could introduce evidence at his trial to say, look, my story has been the same all along. When I was arrested, I said this, I said the same thing in my record of interview, and now here I am today saying this in court. So that is an example of an exception. And also res gesti statements. Because if you think about it, previous consistent statements are a form of hearsay, right? Because they are out-of-court statements that are being introduced to prove the truth of the matter asserted. So that's another reason why they were objectionable, other than just because they tend to artificially inflate the value and weight of the testimony in court. If these previous consistent statements are admissible, then if they go to guilt, they may be admissible as proof of the truth of the contents. It depends on the purpose, the reason for why they're being admitted. Besides having a witness who has just genuinely forgotten a detail and you need to refresh their memory, you may also have two other categories of witness, and these again are your own witnesses. You may have an unfavorable witness. In other words, a witness who is not telling you in the witness box what you really need to establish your case. So we call them unfavorable. We say that they are not coming up to proof. And in other words, they are not testifying in accordance with their witness statement. And there may be a variety of reasons for that. They may have changed their mind about what happened. They may genuinely be able to not to remember an important detail, in which case you may need to refresh their memory. But there's a more severe situation in which the witness is being hostile. A hostile witness is not one who is just not coming up to proof or who has forgotten some details. A hostile witness is your own witness who has deliberately changed their story in a material way, almost in an attempt to defeat you. That's a hostile witness. Now, why would your own witness become a hostile witness, right? I always think of it as going rogue, right? You think they're on your side, and at the last minute, they turn against you when they're in the witness box. They go rogue. Why would they do that? Perhaps they have been influenced in some way by someone on the other side. Maybe they've been paid off to change their testimony. Maybe they've been threatened or induced, subjected to violence by triad members, for example. Right? What is the reason why they have gone rogue and become hostile is one thing that you may need to think about. But in terms of how to deal with this situation in court, you need to ask the court for permission to have them declared as hostile witnesses. The reason you need permission from the court to have them declared as hostile witnesses is because of the foundational principle in terms of evidence law that you can't cross-examine your own witness, right? You can only in examination in chief ask them non-leading questions, but you can't ask them leading questions, you can't cross-examine them. But with a hostile witness, you need to cross-examine them because you need to put to the witness that the version that they are giving in court today is materially different from the version that they gave on an earlier occasion. Okay, so you need to cross-examine them on a previously inconsistent statement. And you may need to suggest to them that they are lying, that they've been influenced in some way, et cetera, okay? So having the witness declared as a hostile witness gives you that permission to cross-examine your own witness and to ask them leading questions. And you can introduce their previous statement. You can put it to the witness to show the inconsistency. You may also want to call other witnesses who can testify that this witness is now being inconsistent today. So a hostile witness isn't where a witness has just forgotten some details or isn't quite telling you what you want, right? This is a very extreme situation where the witness is actively working against you. Cross-examination, very different from examination in chief. This is where you ask questions of witnesses from the other side. And you can ask them leading questions. In other words, you can suggest an answer to them, or you can ask a question which includes a fact not yet in evidence. In criminal proceedings, you can cross-examine a witness on any topic you want, as long as that topic is relevant. In civil proceedings, though, the content of your cross-examination is restricted to the facts in issue, which of course depends on the scope of the proceedings. There's a very special rule in this case of Brown and Dunn, which you must be familiar with. We call this the duty to put your case. And in Hong Kong, you very frequently hear advocates say, I put it to you that, blah, 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 and then they put their question, right? Actually, that's not a great method of advocacy, because as soon as you say to a witness, I put it to you that, they're like, ooh, something's coming that I don't like. So you don't need to use that formal phrase. You can just actually go ahead and ask those questions. But the rule about putting your case means that you have to allow the witness to respond to all material parts of their evidence that you intend to argue are incorrect in closing, right? Let's say that you've listened to the testimony of the witness and evidence in chief, and your conclusion is that this witness is lying, okay? You cannot, in closing, just for the first time, suggest that this witness is lying, because that would be violating the rule in Brown and Dunn. You must, in cross-examining this witness, put to the witness that they are a liar. So, Ms. Chan, I suggest to you that your testimony earlier in court today was not true. Right? You are lying to the court. You are not telling the truth. That's putting your case to the witness. If you do that, you can then argue that in closing submission. It's basically a rule of fairness. You have to give the witness the opportunity to answer your allegations against them where they form a material part of that witness's evidence. There's also this provision in section 154 of the Crimes Ordinance. This actually restricts the scope of cross-examination, because if it is a rape or indecent assault type of a case, then you are not permitted in Hong Kong to ask a witness questions about their sexual history with anyone other than the defendant. So if it's, let's say, a rape case, right? The defendant may be running a defense of consent. He may be admitting that the sexual intercourse took place, but arguing, I thought she consented, so I didn't rape her, right? And sometimes as part of that, he wishes to introduce evidence that they had a long-standing relationship, okay, or that they'd hooked up in the past. It's permissible to ask questions of this victim, complainant, questions about the relationship with the defendant that she had, but you can't ask her about how many other men she's had sexual intercourse with in the past, right? Because that would be very prejudicial in nature. The fact that she has had many sexual partners in the past, the fact that she is perhaps a prostitute, does not mean that she could not have been raped by this defendant in particular. So it's hugely prejudicial, and it's not relevant to whether she was raped in this circumstance. So that's the reason behind this prohibition in section 154. After cross-examination comes re-examination, and re-examination is narrow in scope. You can only re-examine, and this is again going back to your own witness and asking them follow-up questions. You can only re-examine on matters that arose during cross-examination. You can't introduce new topics that were not mentioned by your opponent. Previous inconsistent statements are quite fun when it comes to cross-examining a witness, because you're sitting there listening to the witness give her testimony, and you're thinking to yourself, hold on a minute, what they're saying today in court is quite different from what I read in their witness statement. So this is your opportunity to really almost trap the witness into a corner and make them look either deliberately like they're lying, or make them look completely lacking in credibility, because their story now obviously is full of holes. So this topic applies where a witness is giving different testimony in court from what they said on an earlier occasion. Now, of course, in order to be able to cross-examine a witness on a previous statement, you have to be with what they said on a previous occasion. Because if you don't know what they've said in their witness statement, you don't then know that what they're now saying in the witness box is different, right? So a situation, let's say it's a traffic accident case, and on the previous occasion, this witness in the witness statement said that when the defendant drove his car through the lights, it was green, right? If now in the witness box, they're saying when the defendant drove his car through the lights, it was red, that's an inconsistent statement. So you want to take this opportunity to cross-examine them on it, or do what we call impeach them on it. If the witness says, you're right, I got it wrong, let me clarify, when I said red earlier, I meant green, then that's fine. You don't need to impeach them. They've admitted it. You can argue that they shouldn't be relied on because they made a critical mistake in their testimony. They're not credible. But there are provisions in the evidence ordinance for what happens if the witness denies the inconsistency, right? So this is where you say to the witness, Ms. Chan, you've told us earlier in court today that the traffic light was red, but on an earlier occasion, you said it was green. No, I didn't say that, right? In that situation, you now need to put the previous inconsistent statement before them. So section 13 deals with inconsistent oral statements. Okay, you first have to lay the foundation for it. In other words, on this date and this circumstance, you said this. When you said this, it was accurate, you knew it was important to tell the truth, etc., etc. Then put the inconsistency to the witness. Section 14 deals with where you have an inconsistent statement that's in writing. You need to show that inconsistent statement to the witness. So if it's in the form of a witness statement, you need to direct their attention. Ms. Chan, I am putting before you the witness statement that you made to the police on the 3rd of March. When you made that statement, you knew that it was in connection with criminal proceedings. You knew that it was important to tell the truth. What you said in this witness statement is an accurate statement of what happened. Yes, 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 yes. That's your signature at the end of the document. Yes. Above that signature is a declaration of truth of the contents of the statement. Yes, yes, etc. Okay, that's how you lay the foundation. Then you say, Ms. Chan, I'd like to direct your attention to paragraph 6. Yes. In paragraph 6, you said the traffic light was green. Correct. Right? Then you've pointed out the inconsistency with what she said earlier about the traffic light being red. So in criminal proceedings, these previous inconsistent statements are admissible as to the credibility of the witness only. But in civil proceedings, admissible as proof of the truth of the contents. Okay? So I think from your perspective, be aware of sections 13 and 14 of the evidence ordinance and the requirement to draw the inconsistency to the attention of the witness that you are now impeaching. The next topic that we looked at is what we call the rule of finality. And the rule of finality is a rule that exists in relation to collateral issues. Collateral issue is an issue that is not strictly relevant to the facts in issue in the case. So the best example of a collateral issue is the credibility of a witness. That's something that may be important, but it doesn't go to the facts in issue in the case, whether the defendant committed the offense of common assault. So to prevent a proliferation of the trial, right? To prevent the trial going on and on and on as we argue all of these side issues, there is a rule of finality on collateral issues. That means that if the witness denies that he's lying, for example, then you can't bring evidence to prove the contrary. But there are quite a few exceptions to this. So, for example, previous inconsistent statements is an exception to the rule of finality. You can draw the witness's attention to a previous inconsistent statement that he's made to impeach his credibility, even though credibility is a collateral issue in the case. If the witness denies, if you suggest to the witness, Ms. Wong, you have a previous conviction for shop theft, no, I don't, then your argument's going to be that they have a previous conviction for shop theft, therefore they are dishonest, therefore their testimony is not credible, right? This is why it's a collateral issue. You can, under section 15 of the evidence ordinance, introduce the proof that they have been convicted of this offense if they deny it. You can introduce evidence that the witness is biased, the history of their relationship with the defendant, or that on other occasions, let's say you've done your proper research on this witness, and you found out that on other occasions they've testified in court, and their evidence has been disbelieved. You can put that to them to attack their credibility. Or they may have a reputation for making false complaints, right? Let's say that they have consistently called up the police and alleged that they've been assaulted, and the case has been dropped because there was no basis in those complaints. And here they are again making a complaint of assault against the defendant. You can introduce that history to attack their credibility. Character evidence is a big topic, so we need to spend a bit of time on this. Because remember that there's two sides to character. There's good character and there's bad character. But when we talk about character generally, we're talking about a person's reputation. We may be talking about things that they've done in the past. And we may be talking about expert evidence, really, about a person's personality, characteristics, the way that they behave, etc. And the reason that character evidence is relevant is it may be relevant to, of course, credibility, whether it is more or less likely that their testimony should be believed. But it may also be relevant to propensity, whether it's more likely, for example, for the defendant to have committed this guilty act. Character may also be an important factor and issue in the trial, right? So, for example, if the charge is that the defendant drove while he was disqualified from driving, then you may need to introduce his previous conviction in which he was disqualified from driving, let's say for driving under the influence of alcohol, to show, because it may be one of the elements of this offense, right? So it may also be relevant for matters other than credibility and propensity. So character evidence can be introduced where it's a fact in issue, where it goes to propensity sometimes, where it goes to the credibility of a witness, for example, whether they're biased or generally untruthful, or if they have previous convictions. And also remember section 62 of the evidence ordinance as well. We may wish to introduce their previous conviction in a civil trial, right? Because it helps on one of the elements of our civil claim. So for example, if we're claiming against the defendant in negligence for running us down on the street, right? So this is a traffic accident case. The fact that he's convicted of careless driving can be introduced, and this basically reverses the burden of proof, okay? In some ways, it's not a strict reversal of the burden of proof, but if you introduce it, there's a prima facie conclusion that the defendant has been negligent. The defendant can then rebut it by proof that he wasn't negligent. But remember, the standard of proof in a criminal case is higher than in a civil, so it's hard. So let's look at character evidence in the case of criminal cases. If the defendant is of good character, in other words, he has no previous convictions, good character is relevant both to his credibility and to the likelihood of whether he did this guilty act or not. And we talk about the VI direction, or sometimes we call it the Barada direction. So this is where a defendant gets a direction from the judge to the jury, basically saying that because the defendant is of good character, he's more likely to be credible. Now, this first limb should be given where a defendant of good character testifies in court, or where he's given pretrial statements. Let's say there's a record of interview that he gave, and he said something in that record of interview that was then introduced in court. So a pretrial statement, he would be under the VI direction entitled to that first limb of the credibility direction. But the second limb is in relation to propensity. He's less likely to have committed the act because he's a person of good character. And the VI direction says he's entitled to the second limb, even if he doesn't testify, even if he doesn't make any pretrial statements. So the VI direction basically distinguishes between the case where the defendant says something in his defense, where he testifies or he gives a pretrial statement. If he doesn't testify, if he exercises his right of silence, then under VI, he's only entitled to the second limb, which goes to propensity. Now, the situation is a bit different in Hong Kong because we have this case of Tang Siew Man, which held that in Hong Kong, there's no requirement for the trial judge to give the VI direction. Rather, there's a discretion in the hands of the judge whether to give the VI direction or not, because the overall requirement is that the summing up is fair and balanced. What that means is that it refers to all the essential parts of the prosecution case, as well as all of the essential parts of the defense case, and it doesn't unfairly emphasize one or the other. But Tang Siew Man does go on to say that where evidence of the defendant's good character has been introduced at the trial, then a summing up which doesn't give both limbs of the VI direction may be unfair and unbalanced. So you can see that reflected in SJD 37. Okay, so technically no requirement, but if a defendant is of good character and he testifies in court, it'd be very unusual for the trial judge not to direct the jury on both limbs of the VI direction, because that may be unfair and unbalanced. Now, what if the defendant is of bad character? He has some previous convictions. The rule is that for bad character, it's different. Bad character only goes to credibility, not to propensity. In other words, the fact that he has previous convictions makes it less likely that his testimony is believable, but it does not make it more likely that he committed this offense. Now, where the defendant is of bad character, as defense counsel, you need to carefully talk through with your client they should testify or not. And you need to have section 54(1)(e) and section 54(1)(f) of the Criminal Procedure Ordinance forefront in your minds. Because section 54(1)(e) says that if the defendant does testify, he has no privilege of against self-incrimination in respect of the offense he's charged with. So he can be asked questions about whether he committed this offense in cross-examination. His privilege against self-incrimination only extends to other offenses he's not charged with. So that's section 54(1)(e). So you have to warn your client, you will be cross-examined and the prosecution will suggest to you that you committed this offense, et cetera, et cetera. Section 54(1)(f) deals with the situation of the general principle that a shield against being cross-examined on his previous convictions. In other words, he's protected generally from the prosecutor putting his previous convictions to him in cross-examination. But his shield can be lost in certain circumstances. And section 54(1)(f) sets those circumstances out. A couple of things to bear in mind for section 54(1)(f). Firstly, it only applies to a defendant. Right? If it's a defense witness or a prosecution witness, section 54(1)(f) does not apply. So there is no shield against being cross-examined on previous convictions for any other witness other than the defendant. The defendant is the only witness who has this shield. So you're perfectly entitled in cross-examining prosecution witnesses to put their previous convictions to them, as long as they're relevant, okay? So section 54(1)(f) only applies to a defendant, and it only applies to a defendant who testifies. So this is one of the relevant considerations. Should a defendant testify? Should he not? Because if he testifies, he may be asked about his previous convictions if he's lost his shield under section 54(1)(f). But there are other ways in which his previous convictions may come out, even if he doesn't testify. Of course, as to whether he can be cross-examined on previous convictions or not, we still have to consider general evidential principles, right? Is the previous conviction relevant? Because if the previous conviction is very minor in nature, occurred 50 years ago, and is completely different in nature from what he's currently charged with, then it may not be relevant. It may be more prejudicial than probative. So even if he's lost his shield, the prosecution may still not be permitted to ask questions on it. So first part of section 54(1)(f), subparagraph I, deals with where the prosecution want to introduce a previous conviction as proof that the defendant committed this offense. Okay, so by that, we are covering the example I gave to you previously of driving while disqualified, for example. It's an element of the offense. It's also possible maybe similar fact evidence generally falls within this, but that's a common law exception. Subparagraph 2(i) is where the defendant puts his own good character in issue. For example, he decides to testify and he says, I'm a person of good character, but actually he's got previous convictions. Or he calls his priest, who says that he's a fine, upstanding member of the church community, and he's got previous convictions. So in the way that he's presented his defense, he's put his good character in issue. But we look to the case of Chow Hon Kwon, where the defendant inadvertently, well, maybe deliberately, presented a misleading impression of the facts as well. That could also amount to putting your good character in issue. If the defendant does that, then the prosecution is entitled to cross-examine him on his previous convictions. And actually, I shouldn't say entitled, because at the end of the day, it's still in the discretion of the court. But in that situation, the prosecutor would assume that the shield had been lost based on putting the good character into issue. But what he must do before he cross-examines on the previous conviction is he must ask for leave of the court. The reason the prosecutor has to do that is to make sure that the shield has really been lost, because that's a matter of law for the judge. And the prosecutor doesn't want to risk bringing out potentially inadmissible prejudicial evidence, say, before the jury that may lead to a mistrial. So they'd always ask for leave before they cross-examine on previous convictions. Also, another situation in which the defendant can lose his shield is where he impugns the character of a prosecution witness or the prosecutor, saying, for example, that the police have fabricated evidence against him, or they threatened him, or they induced him, or they bribed him, or they beat him up. That's impugning the character of a prosecution witness. And whether the shield has been lost or not is really a question for the judge to decide. So if the defendant just denies that he committed the offense, that's not impugning the character of the prosecution witness. It has to be something stronger than that. Or just saying that the complainant consented in a rape case is not impugning their character. You'd have to put to the witness that they are deliberately lying, fabricating evidence. That would probably be impugning their character. Impugning the character of the prosecutor is more rare. An example of that would be if you say that the prosecutor has deliberately withheld evidence or deliberately put forward something that's false before the court. That would be impugning their character. The third exception is where there are co-accused in the case, and let's say D1 testifies against the co-accused. Now, what this means is that D1 gives evidence which either supports the prosecution case against D1 or against D2 or undermines D2's case. That's what we mean by testifying against a co-accused. If all that D1 does is get into the witness box and says, I did not commit this offense, that is not testifying against a co-accused. But if D1 gets into the box and says, I didn't do this offense, it was D2, that is giving evidence against the co-accused. And we see this commonly in a situation of what we call a cutthroat defense. Cutthroat defense is where A says that B did it and B says that A did it. So they run these cutthroat defenses. Now, if you look here, I'm just going to highlight this. This is in your original notes for lecture 3. Let me just sort of enlarge this so you can see it a bit better. Oh, it's not allowing me to do it. I'm just trying to enlarge it. Anything else? No. It's not allowing me to enlarge the comments, but you can see it says at the bottom, note, trial judge has no discretion to prevent the cross-examination by a co-accused on defendant's previous convictions. Actually, that's not correct. If you look at the evidence unit guide, let me just find the relevant provision. So it is here also in the evidence unit guide. So let me just, hold on, give me 1 second. This bit needs to be corrected because although the case of Murdoch and Taylor suggests that co-accused can just launch into cross-examination on a defendant's previous convictions, actually the situation in practice is different. A co-accused counsel would always still ask the court for permission, leave, before cross-examining on the defendant's previous convictions. The reason for that is it's really a matter of good practice because, again, they don't want inadmissible, prejudicial information coming out before the court. So although Murdoch and Taylor suggest this position, actually in practice in Hong Kong, co-accused counsel always ask for leave before they cross-examine on previous conviction. So you can see that that's kind of reflected here with what I've said next, right? It doesn't say in section 54(1)(f) that you need to ask for leave, but this is a matter of practice in Hong Kong. And the same is true for co-accused counsel as well. And it stems from this discretion to exclude evidence that's more prejudicial than probative, for the judge to make sure that the shield is really lost, and for the judge to determine that these previous convictions are in fact relevant. Okay? So you can just make that note yourself. But yeah, if the court gives them leave, then they can. But it's up to the judge to decide. He has a discretion still to refuse it. Sorry? In the evidence unit guide, it's page 83. So just make a note to correct that on page 83. Okay. And I've corrected it here on slide 28, okay, in lecture 3. I just didn't track it through into that note. So you can see it here. Co-defendant who wishes to cross-examine defendant under this will also need the judge's leave to ensure that the shield is really being lost. So it's correct at this bit in your notes. It's just not correct earlier. And emphasizing here, they should still ask for leave even if the shield is being lost as a matter of good practice. Now, we said earlier that if the defendant is of bad character, then the general principle is it only goes to his credibility, not to his propensity. But there has been an exception made in some cases. I'll just highlight these for you here, since we're on this slide. So in the Queen and Randall, which has been followed in Hong Kong in Wong Ying Kit, in this case, evidence of the defendant's bad character was found to be relevant to propensity, not just credibility. And this was where the defendants is a murder trial and they were running cutthroat defenses, each blaming the other. In this case, the direction given to the jury was that their previous convictions may be relevant to the likelihood of which of them committed the murder. And that was because of the unique situation of the cutthroat defense, and they were both blaming the other. Okay, but that's a very narrow exception for a cutthroat defense. Okay, so just be aware, generally the rule is bad character doesn't go to propensity, but there has been this exceptional carve out in the cutthroat defense situation. Previous convictions may also be admissible sometimes by statute, right? And there's section 29, section 3 of the theft ordinance. There are some common law exceptions as well. So even, remember section 54(1)(f) only applies where the defendant testifies. But if he doesn't testify, let's say he calls another defense witness who says he's of good character, then the Butterwasser exception is that as a common law exception, the prosecution can introduce evidence in rebuttal to show that the defendant isn't of good character, that he has a previous conviction. There's also the principle of similar fact evidence, right? Because if we think about it, a defendant could just decide, oh, I've got previous convictions, I'm not going to testify, so section 54(1)(f) isn't triggered, and I'm going to call all of these good character witnesses who are going to talk about how fabulous I am. And then the prosecution will be left in a very difficult position. So these common law exceptions are designed to provide for that situation. So we'll look at similar fact evidence in a minute, but that's a possible way in which the defendant's previous bad behavior or previous convictions can be introduced. But for witnesses other than the defendant, they can be asked about their previous convictions. They can be asked about previous occasions where their evidence is found to be untrue, as long as it's relevant, probative, and admissible. I don't think you need to worry about that. Yes, sure. Right. So if it in cross-examining a witness, you suggest to the witness that he's lying, right? Then the witness cannot call evidence of other witnesses to show that he's a person of good character, right? Because this is the rule of finality, right? This is preventing the proliferation of collateral issues, okay? And it's up to the prosecutor and the defense counsel to decide what is the evidence that's put forward, right? It's not up to the witness to call his own witnesses. Okay, so that's where we left lecture 3. Lecture 4, we dealt with similar fact evidence, hearsay, and the very many exceptions to the rule against hearsay. So let's take a 10-minute break because these are important topics, and then we'll come back and we'll start with similar fact evidence, okay? When there are both UK and Hong Kong cases for a principal, should we cite the Hong Kong case or both? Of course, like now we have our own body of jurisdiction, right? So cases in the UK are for sort of reference, right? But we're not obliged to follow them. So the Hong Kong case, of course, is more authoritative, but sometimes the Hong Kong case has adopted the UK position, right? So I can't give you a straightforward answer to that. Oh, before we break, I wanted to say last night someone asked the question about the new remote hearings ordinance, right? And we said that generally it doesn't apply for criminal trials, but there are some parts of the criminal trial that you may be allowed to have witnesses testify remotely. One of the other things that this new ordinance has done is it's effectively abolished section 79I of the CPO, because it's put into place this whole new ordinance allowing for remote hearings. But for your purposes, because this new ordinance has come in so late in the day, we're sticking with the old position, right, in which this ordinance effectively for our exam purposes doesn't exist, okay, because it's just too close to your final exam. All right, so we're going with the old provisions, okay? And actually the ordinance itself sort of provides for that, right? Because it says if the case is kind of ongoing and an application has been made, then we carry on with the old provisions, okay? So we're going to apply that same principle for the exams, okay? All right, so let's take a minute break and we'll come back and we will talk about similar fact evidence. Okay, so let's get into the difficult areas that all evidence law students dread: similar fact evidence and hearsay. So similar fact evidence is a common law introduction, basically, to reform in which it was necessary for evidence had behaved on a previous occasion or evidence of his previous convictions to be in the case. Let me see. This one's a bit better. It seems like the battery is running out on this one. Okay, so this is where we're talking about a situation of introducing evidence which is not in relation to the offense that the defendant is currently charged with, but is evidence of how he's behaved on a previous occasion. So you can see here in the notes, it governs the admissibility of evidence which doesn't directly implicate the accused in the offense charged, but suggests either directly or indirectly that he's committed one or more other offenses in the past. So in a situation where similar fact evidence is admissible, it is introduced to show the guilt of the defendant for the offense he's currently charged with. So we have a whole history of cases, Rodley, Barrington, Macon, Thompson, Boardman, etc., which are set out in some detail in your notes, which go through the tests of when similar fact evidence would be introduced. So it used to be thought that the sole criteria was whether there was a striking similarity in the manner of commission. For example, if the defendant had a previous conviction for robbery, and in that case, he used a getaway car driven by a man dressed up as Donald Duck, and he robbed a bank dressed up as Mickey Mouse, and he's now charged with another robbery, and the allegations are that the MO, the modus operandi, was the same. So there's a pattern of behavior, then the prosecution may be able to introduce that MO because of the striking similarities in the manner of commission. We looked at how it used to be thought that there was a special category for homosexual offenses based on the case of Thompson, where there was the allegation against a man that he'd indecently assaulted some young boys, and he was seen kind of talking on the 16th, and then he was seen talking to them 3 days later, but he didn't do anything offensive on the later date. But the prosecution wanted to admit other evidence that he was found with some makeup items in his possession and that he had photos of naked boys in his house, right? None of that went to whether he'd actually indecently assaulted these boys on the 16th. But the House of Lords was of the view that you needed to be a particular kind of person to commit these offenses against young boys, and that these photos and the makeup that he was found in his possession were, in fact, able to be admissible as proof of his guilt. And we have the case of Boardman as well. The current position in the UK is set out in the case of DPP and P. Whether similar fact evidence would be admissible depends on whether it's relevant to the facts in issue in the case and whether it's really probative of those facts in issue. It cannot be introduced just for propensity reasons. That's what's called the forbidden reasoning. And DPP and P says that if the evidence of the manner of commission is strikingly similar, that's just one consideration for the court, but it's much wider than that. And in fact, similar fact evidence can be introduced in other situations, like, for example, to rebut a defense of accident or coincidence. But one of the key considerations is whether the evidence has sufficient probative force to justify its inclusion into evidence, notwithstanding its prejudicial nature. And in Hong Kong, the leading case is Hong Kong SAR and Zabid Ali. So in these cases here, similar fact evidence was able to be introduced where the identity of the defendant was one of the issues in the case, like in the case of Thompson, or the intention of the defendant was one of the issues in the case. In the case of the brides in the bath, right? Evidence that his wife had died in similar circumstances was able to be introduced alongside evidence that he had recently changed his wills as evidence of his intention to murder his wives. Evidence of the defendant's motive was able to be introduced as similar fact evidence. In the Lau Pui case, the prosecution was able to introduce evidence that the defendant had been reported by the prosecution witness for being a triad member, and that then was relevant to the defendant's motive for trying to murder the prosecution witness by blowing up a building that he was in. So what is the test in Zabidali? So I've summarized for you here all of the facts of the case. And I think you can really read through the background. But the issue in this case was whether the evidence of a prosecution witness, Omar, was admissible. And the defendant had apparently had this conversation with Omar in which he said he was going to kill someone to avenge his father's murder. But why it's relevant for your purposes really is that the Court of Final Appeal said that evidence of bad character may be admissible in, if it falls within similar fact evidence, if it is relevant to an issue in the case, and if it is introduced for reasons other than to show propensity to commit the offense. So they approved the test in DPP and P. Does its probative value outweigh its prejudicial effect? So there's basically a four-stage test for admitting the evidence. First of all, the court will consider what are the matters in issue in the case. And then they will ask, what is the evidence relating to those matters in issue? Next stage is, what is the matter in issue to which the evidence is said to be relevant and why? In other words, why is this evidence probative of these matters in issue? And if it's relevant for a reason other than just to show propensity, then we apply the test in DPP and P. In other words, the court will think about whether its probative force is sufficiently great to admit it, notwithstanding its prejudicial value. So that's essentially the test. And if the similar fact evidence is introduced, then the jury should be directed on how to deal with this similar fact evidence. In other words, that it's not evidence of propensity. Instead, it's evidence of guilt. Now, we have said, I think before, that as a general principle, the fact that an accused has been previously acquitted on other occasions is not admissible evidence because it's very prejudicial in nature, and it's also not relevant. There is the risk that if the previous acquittals are introduced, that a jury might think, well, he got off before when he was charged with the same offense. Maybe it was because of some technicality. Therefore, we better make sure he doesn't get off again, even though the evidence in the case does not support a conviction. So that's the general reason why previous acquittals of the defendant are inadmissible. However, there is a narrow situation, I think, in R and Z, in which evidence of previous acquittals were allowed to be introduced. And this was in a rape trial in which the defendant was for the fourth time charged with rape, and he'd been acquitted 3 times previously. And in all of those 3 previous cases, he'd run the defense of consent, and he was again running the defense of consent. So those previous acquittals were able to be introduced. But I would suggest that this situation in RVZ is a very narrow exception. And generally, if the prosecution do introduce the defendant's previous acquittals, it is a hugely inappropriate thing to do. It is a significant and serious error because it has a huge prejudicial effect. And the judge then needs to consider what to do with it. But there have been a number of cases in which it has led to the immediate discharge of the jury and a mistrial because it is seen to be highly prejudicial in nature. So similar fact evidence is dealt with in SJD 22, which you can take a look at. Okay, so hearsay evidence. General principle, if a statement is made outside of court and the purpose for introducing that statement is to prove the truth of the matter asserted, then it is hearsay and it is inadmissible. But we can have various different types of hearsay evidence, right? And actually, the situation is that, let's say, A makes a statement to B, and he says the traffic light was green, okay? B then talks to C, and B says to C, A's just told me that the traffic light was green, okay? So here we have A making a statement, it was overheard by B, and B tells the statement to C. So we have 3 different people involved. It all takes place outside of court. If the purpose for introducing A's statement is to prove that the traffic light was green, then it's hearsay. And it's hearsay no matter whether A wants to testify that he said that outside of court on another occasion, that the traffic light was green, it's hearsay. Is hearsay whether B says, I overheard A say the traffic light was green? And is hearsay if C tries to say, B told me that A said the traffic light was green, right? If the purpose of introducing that statement is to prove that the traffic light was green, is hearsay, okay? Now, if the purpose for introducing the statement is not to prove that the traffic light was green, but just to show for a different purpose, sometimes to show somebody's state of mind, then it's not hearsay. So you always have to look at what's the purpose for introducing the statement, right? Now, in the example I gave, it's hard to imagine what other purpose there could be for introducing that statement other than to prove that the traffic light was green, okay? But there may be other situations where a person's state of mind is relevant. And actually what you want to do is introduce the statement either to show their state of mind or maybe even to show that this statement was just made at all, okay? So just because a statement is made outside of court doesn't mean that it's hearsay. You must always look at the purpose for which the statement is being introduced. Now, we have this very controversial case of Kearley, which really relates to implied hearsay. In this case, the police officers had basically done a raid on a premises where drugs were being trafficked. And they stayed in the house for hours afterwards and they intercepted a number of phone calls. And in the vast majority of the phone calls, there was no explicit communication like, I want to buy 10 grams of cocaine, right? But the caller said something like, I want my usual order, right? So the prosecution wanted to introduce these statements as implied hearsay that the defendant was guilty because they wanted to introduce the fact that the usual order meant he must have supplied drugs on previous occasions. Therefore, he was involved in trafficking. But the court actually disallowed this evidence because they said it fell within hearsay, even though it was just implied. But I think the modern trend now is more in line with these Hong Kong cases here, Or Soon Hong, Oi Henki Wiru. The prosecution have managed to be a little bit more inventive, let's say. And they've said that this evidence is not being admitted to prove the truth of the contents, what was said, but to show that the defendant was engaged in this type of conduct. So, for example, in Oi Henki Wiru, the evidence, the hearsay evidence, was entries in a bookkeeping record of illegal betting. So the prosecution said, we're introducing this evidence not to show that these particular bets were made, to prove that the truth of the contents that these bets had been made, but to show that these were the kind of records kept by illegal bookkeepers involved in this type of activity. So that's how they managed to get around this implied hearsay issue. There's also the concept of negative hearsay. And actually, you can introduce evidence that in the typical course of affairs, if everything had been done as it should have been done, you would have expected there to be a particular entry, let's say in a record. And the absence of that record shows the fact that it wasn't done, it didn't take place. So those are the cases here of Patel, which is a common law exception, but also we have our own statutory exception in section 17A of the evidence ordinance, and the case of Shum Yu Kin. This was a case where the defendant was charged with shop theft, and he said that he had purchased the items, but the prosecution were able to introduce evidence to show there was no record of those purchases being made on the cash receipts. Hearsay largely is not an issue in civil cases because it can be admissible as long as notice is given to the court, as long as this evidence is reliable, etc. And it's not prejudicial in nature. So those are the provisions section 46 to 55B of the evidence ordinance. So it's really just in criminal cases that we really face this hurdle of trying to find an exception to the hearsay rule to allow this evidence to be introduced. So the common law has come up with many exceptions, and there are a number of statutory exceptions as well. So first exception is from the case of the Queen and Rogers, a declaration against interest by a person now dead. So if the deceased has personal knowledge of a fact that he makes a statement about, if the declaration is against his financial or proprietary interests, for example, he says, I owe Mr. Chan $500,000. And when he makes that statement, he knows it's against his interests, and he then dies. Evidence of what he said against his pecuniary interests can be introduced as a declaration against interest, because it's felt that that evidence would be more reliable. Because why would somebody say something that's not in their interests, their financial interests? So that's the case of Rogers. We also have the situation of a dying declaration, and Bedingfield and War set out the requirements. So a dying declaration only applies if the person who said the statement is now dead. It's a murder or manslaughter trial, but we looked at this Canadian case of Jerton, which finds that as long as causing the death of the person who made the statement is an element of the offense charged, it doesn't have to be a murder or manslaughter trial. So in that case, it was a traffic accident in which the declarant had been killed. That dying declaration was able to be made or admitted in that trial. The declaration has to relate to the cause of death. So, for example, A says, it was B who stabbed me. It has to relate to the cause of death. The declarant has to have been a competent witness, and they have to know that they're dying at the time that they make the statement. And it has to be a complete statement. So if the declarant just says, I was stabbed by, and then dies, right, it's not admissible as a dying declaration. Now, I added this in for tonight's slides. It's not in your lecture 4 slides because there's a third common law exception, a declaration of some business matter pursuant to a duty. So just to be complete, I've added this slide in for tonight. So this is where a person in the regular course of their duty makes a contemporaneous record of some business matter which he was under a duty to transact. If he subsequently dies, then evidence that he made this business record can be introduced to prove that the transaction took place. So this is, you have to satisfy these requirements. He has to be acting in accordance with his duties. It has to be a contemporaneous record. It has to be a business matter that fall within the scope of his duties, and he then has to be dead. Okay, now, I don't think you need to, this is not new information, okay? It's just that I left it out of the slides mistakenly when we first went through unit lecture 4. But if you look at your notes for this topic in the unit guide, right, we're on topic 18. You'll see here we've got declarations against pecuniary or proprietary interests. We just looked at that. And we have the exact content of it here in the unit guide. So you know it. It's in your notes already. It's at page 104 in the unit guide. It just wasn't in the slides that we talked about at the time. Okay, so you have that information already. And then there's the fourth common law exception, which is res gestae. Res gestae really typically applies in 3 kinds of circumstances. But I think the most common circumstance is a spontaneous, excited utterance that is contemporaneous to an emotionally overpowering event, from the case of Andrews and Rattan. So the idea here with this is that the mind of the declarant has been so overcome by what's just happened to them or what they've just seen that there is no possibility that they could have concocted this statement. So let's say a horrific train crash, and the declarant then says something and then dies. In Rattan, it was in relation to a woman sobbing hysterically on a phone call to the police when she'd just been shot. So they were able to infer that this was an emotionally overpowering event, and that statement of what she had said on the phone call was admissible. So the first exception is a spontaneous, excited utterance in response to an emotionally overpowering event. If you want to look at your notes in more detail for the unit guide, right, set out here, page 105. So you can see here Andrews. So there's 4 relevant factors. There was an unusual or startling, that should say, not starting, should say startling, dramatic event. The event dominated the thoughts of the maker of the statement. As a result of the domination of thoughts, the statement was an instinctive reaction to the event. It was spontaneous. And the statement was approximately contemporaneous with the event, right? Because it has to be a spontaneous utterance. How approximately contemporaneous is a question of fact in the cases, right? But if a statement is only made 10 minutes later, half an hour later, it's not approximately contemporaneous, okay? Second situation of what can fall within res gestae. Again, I've revised this slide a bit for you today, but you have it already in your notes. This is contemporaneous statements accompanying an act from the case of Bliss. So if you go back to your evidence unit guide, you can see that these principles here, like what's the criteria? So the statement made has to be approximately contemporaneous to what the act that's being done. It has to be made by the person performing the act, and the act should be relevant to the issues in the case. So those cases are all there for you in your unit guide at page 105. So an example of that could be, let's say, I don't know, the defendant stabbed someone, and as he stabs someone, he says something, right? So it's contemporaneous with the act. He's performing the act of the stabbing, and he says something, and of course the act is relevant to the case. Okay, so that's an example of that res gestae. But there's another exception which is quite narrow in scope, which is contemporaneous statements relating to the maker's physical or mental state. The statement here has to be solely in relation to their physical state, right? So in other words, I'm in pain because I've just been bitten by a snake would fall within the res gestae exception here. Or evidence of their mental state. Okay, so the other exception we know about already from the case of Osborne and Virtue, that if the person who made the identification in the ID parade is unable to give that identification because they've forgotten, then Osborne and Virtue provides that, say, the officer in charge of the ID parade can give evidence of the fact that they did identify the defendant. That is technically hearsay, but it's permissible under the exception for prior identification at an ID parade under Osborne and Virtue. We also have a lot of statutory exceptions. So we've talked about section 17A of the evidence ordinance, where there's a system in place to record certain events. The absence of a recorded event is a negative assertion from which it can be occurred that the event did not happen. So you need the happening of an event, you need a system that's followed, a person acting under a duty has compiled a record of all of the things that happened, and actually there's no record of what's happened. So an example of this could be in another scenario, other than the case in Shum Yu Kim. Let's say in my building, anytime someone enters a building, the security guards have a logbook and they make a record, right? They ask to see the person's ID card, they note down their name and their ID card number, right? So they are acting under a duty, there's a system in place, they record the entries to the building. Now, let's say for some reason it wants to be proved that a person didn't enter the building. The fact that there is no record of them entering the building could be introduced as under section 17A as a negative assertion. Okay, another statutory exception is in the case of bank records under section 20. As long as you meet the criteria here, it can be admitted as prima facie evidence of the fact that these matters are generally recorded in the ordinary course of banking business, that then some person has looked at and compared a copy with the original, etc. It means basically that the banker's record, like the bank statement, for example, can be introduced into evidence without needing to call the person at HSBC who compiled all of this information. Okay, but you have to go through and meet all this criteria here. When we looked at the statutory exceptions, we spent some time on section 22 of the evidence ordinance. This is in relation to documentary records compiled by a person acting under a duty. And we said that the document is admissible as prima facie evidence of the fact. In other words, it's admissible as proof of truth of the content. As long as it would have been admissible by direct evidence of that person, it forms part of a record compiled by a person who was acting under a duty from information supplied by a person, and the supplier doesn't have to be under a duty to supply the information, but they have to have had personal knowledge of those facts. And they are not available to give evidence. The supplier of the information cannot be called to give evidence because under section 22(1)(c), perhaps they're dead, they're outside of Hong Kong, or we don't know who they are. You should also remember that under this statutory exception, the compiler of the information and the supplier of information can be the same person. So this section applies as long as someone is compiling a record and they are acting under a duty, okay, even if nobody else is giving them the information, okay, as long as it's a documentary record that's kept. But there are other exceptions in section 22E, evidence ordinance. If the document is prepared in contemplation of criminal proceedings, we cannot use this statutory exception. So a police officer's notebook or a record of interview, although they may be compiled by a police officer acting under a duty from information supplied to him by someone else, they are prepared in contemplation of criminal proceedings, so they cannot be used. We may have another way to get them in, but not under Section 22. We have also Section 22A of the Evidence Ordinance in criminal proceedings. These computer records can be admitted for proof of the truth of the contents, as long as we meet the criteria in Section 22A. Now, the difference between 22 and 22A is in a situation in 22A, we usually use this section when we have a computer that's performing some type of automated function. Like, let's say that a person manually inputs a deposit into a savings account, but the computer system then calculates later the amount of interest on that deposit. Okay, that would be a situation for 22A to be used. But if all that's happened is the person has created a documentary record and nothing has changed of that inputted information, then you'd use Section 22. And remember, for all of these statutory exceptions, there are exceptions to the rule against hearsay. So in all of these cases, these records are being introduced to prove the truth of the matter asserted. If a record is being introduced for some other reason to show it exists, then we don't need to rely on these statutory exceptions. So Section 65B, for example, of the CPO, this isn't a statutory exception to the rule against hearsay, because this is admission of a written statement, and it just stands as if the evidence of the witness had been testified to in open court. So it's not proving that what is said within it is true. So don't be scared by a question on hearsay. I know it is scary sometimes, but if you break it down step by step, if you think about, okay, first question, is it an out-of-court statement? It's always fairly easy, right? Then think about, what is the purpose for which this statement is sought to be introduced? Is it to prove that what is said in the statement is true, that A stabbed B? Or is it being introduced for some other reason? For example, to show that the statement was made, or to show the state of mind of the person who said it. So in that case, there may be situations in which the evidence is able to be introduced because it's not being introduced for a hearsay purpose. So let me just look back at the notes for a second. Just want to make sure we've covered all of these exceptions. Bank records, documentary records, computer records. Another key exception to the rule against hearsay, which is not really dealt with in this topic in your notes, but we've talked about it already, is what a defendant says, right, when he's arrested. It's an admission against interest. That is an exception to the rule against hearsay. So if when the defendant is arrested, he confesses, right, I killed him, the purpose for introducing that statement is to show that the defendant has confessed to the crime, that he did kill this person. Okay, now, a confession is also a common law exception to the rule against hearsay. It is admissible. And we looked at it when we talked about confessions, or when we talk about confessions. We'll get onto that, I think, tomorrow night. But we also talked about it in the context of a previous consistent statement, right? That if he said that when he was arrested and he said that in the record of interview, then that could be introduced. Okay, so confessions against interest are also an exception to the rule against hearsay. Okay. Any questions about what we have covered tonight in terms of the refreshing on the content? No? Yes. Contemporaneous. Mm-hmm. So the question is, for refreshing memory, if the document is not contemporaneous, can it be used to refresh a witness's memory? Actually, so the case law is not very clear on how contemporaneous is contemporaneous, right? Because most of the time when a witness gives a witness statement, that's not done at the scene of the crime, is it, right? it would either be some hours later or even potentially some days later. Okay. So there is no real guidance on how